10 seconds, 5 seconds. Start. The court strikes a balance between the case of the plaintiff and the defense raised by the defendant. The proportions laid by the Supreme Court in its various decisions may be summed up as follows. If the defendant satisfies the court that he has a good defense to the claim on merits or raise a triable issue, the defendant is entitled to an unconditional leave. And if the defendant discloses such facts as may be deemed sufficient to entitle him to defend, the court may impose conditions as to time of trial or mode of trial. On the other hand, if the defendant has to defense or a sham or illusory defense, the defendant is not entitled to leave to defend. In the case of International Computers Consultants versus Home Computers Services Limited, a division bench took the view that once tribal issues are raised with bona fide and firm defense, leave should be granted. But if the defense is frivolous or vexatious, leaves should be refused. Where there is reasonable doubt and the court feels it just reasonable, the court may impose such condition while granting the leave as it may deem fit and proper. Applying the said principle to the present case, I have no hesitation in affirming the view taken by the learned trial court that the defendant may have raised triable issue but it lacks bona fide. Judicial discretion to be exercised by the court has to create a balance so that none of the parties to the suit suffer avoidable prejudice. The learned trial court had only granted conditional leave to the defendant applicant, in which I see no error of jurisdiction. Above principles of law are well enunciated and accepted principles. Learned counsel appearing for the plaintiff applicant contends that this court has jurisdiction and complete case of the applicant is a sham defense, thus leave prayed for should be rejected. Let us examine the facts of the present case. The plaintiff has filed on record copies of 3 checks. He has also filed on record a copy of the notice dated 31st March 1994, allegedly sent to be defendants for payment of rupees 30 lakhs. It is strange that the stand taken by the plaintiff in the notice is at complete variance to the claims made in the plaint. The loan transactions referred to in the plaint did not find a mention in the notice. In the plaint, the claim is based upon 5 checks, while the notice only refers to 3 checks. The inconsistency in the stand taken by the plaintiff prima facie creates a dent in the case of the plaintiff and lends credibility to the stand taken up by the defendants. Why would an income tax consultant not even get a receipt acknowledging the payment of such amount, particularly when they are being made in cash? There is no justification stated on record as to why the plaintiff has not filed on record the two checks which were not even presented to the bank for encashment.